Hi, in today's episode, I'm going to tell you about my experiences working as a plaintiff's workers' compensation attorney for several years. It's an area of law that I don't handle anymore now that I'm a solo practitioner and have been solo for about 14 years now. But when I practiced workers' compensation, it was definitely a lot of learning on the job. This was not anything that law school had prepared me for. In fact, back at Georgetown Law School, they certainly didn't offer any classes about workers' compensation law. First of all, it's very state specific. So anything I'm going to say, not only is it going to be outdated because I haven't practiced workers' compensation since probably about maybe 2008-ish, 2009-ish. And also every state has a totally different system for administering workers' comp cases. So workers' comp means that somebody has been injured on the job. And so they're entitled to compensation based on the statutes and case law and everything. And as an attorney, your goal is to try to get the client benefits, health benefits, get them their weekly payout. And if the person has a certain percentage disability, for example, if they lost a limb or they can no longer do their job anymore, if they have like a partial disability to their hand, for example, from the workplace injury, then they're also entitled to additional compensation for that, at least under North Carolina law. So the way the attorney makes money off of that is that typically the attorney would get a percentage of whatever settlement or benefits they're able to get for the client. And in some cases, some more egregious cases, the what's called the industrial commission, which is like the court system for workers' compensation here, they can also additionally award attorney's fees on top of the benefits that the person is entitled to. That way the person does not have to take money out of their benefits to pay their attorney. So it can be lucrative. I mean, there are certainly a number of firms, mid-sized firms or firms with at least, say, like, I don't know, 3 to 10 attorneys or so that solely do workers' compensation as well as Social Security disability cases. So those kinds of cases kind of go hand in hand. But this is definitely not a glamorous part of law. In fact, I never really knew much about workers' compensation cases when I was a law student. So you're basically helping mostly blue-collar workers, the types of people that tend to get injured more often on the job, you know, people that are working in factories, have repetitive stress injuries, or, for example, people working in nursing homes like CNAs, people who are lifting patients at the hospital or medical care facility who get hurt on the job, people who get assaulted on the job. Although at one of the firms I worked for, we did have one person who worked for a big corporation who suffered a back injury when she bent over and had to lift a heavy load of paper or some supplies or something. But that's kind of rare. I mean, most of the time the clientele are people who, you know, maybe didn't even graduate from high school, for example. Most of them are low-income people. So it's going to be a different kind of clientele. And then also around where I am, it definitely helps if you know how to speak Spanish, because many of the people working around here in those types of blue collar or manual labor type jobs who tend to get injured, they are Spanish speaking people. Was it enjoyable to do workers' compensation? Well, I mean, sometimes there was some satisfaction in terms of helping people who were truly injured and being bullied by their employer or being bullied by the insurance adjuster. And so you really want to fight for the little guy, because those are your individual clients if you're a plaintiff's workers' compensation attorney. But on the other hand, you know, credibility is key. Just like I explained in the personal injury practice video that I recently filmed. You know, sometimes you are representing people and you talk to the witnesses, you start looking at the medical records and you're like, wait a second, this doesn't jive. Or okay, so you were involved in this type of auto accident after the alleged workplace incident. Why didn't you tell me about it? Or, oh, the medical records actually say something about you being a drug addict and that you were constantly going to the hospital to try to get some medication. You know, there's always something that the defense attorneys are going to nitpick on to say that, first of all, there was no accident on the job, that the person already had some sort of problem, that the person's exaggerating, they're good to go, they can go back, they're not really that disabled, or they have no ongoing wage loss or ongoing injuries. So this is where having some sort of medical knowledge is going to be really handy. A lot of times, the attorney just winds up having to look through tons and tons of medical records, to see what's going on with the client and basically follow along with their medical treatment. There were times that I had to go with the client to go see a doctor or get a second opinion, or I would have to meet with the client along with a vocational specialist that was hired by the insurance company to supposedly see, what kind of jobs the person is interested in and what could they possibly do. But that's another place where having an attorney can help, because sometimes the people that work for the insurance companies, they're trying to push the person to get back to work or get a job, another job as soon as possible. That way they don't have to pay for that person's average weekly wage. So I remember I had a client who was making auto parts in a factory somewhere and suffered a wrist injury. And she was assigned a bunch of different vocational specialists who seemed to be, it seemed kind of shady. There was a new voc person every couple of months or something. It seemed like there was a lot of turnover in this company that was supposed to help find jobs for workers' compensation people. And they even wanted her to do all sorts of weird jobs, like something involving taking care of pets or climbing up a water tower to check on water levels, jobs that she clearly was not qualified to do and had no experience doing. So it's not just a matter of preparing for hearing and arguing for your client at an industrial commission proceeding. A lot of it is just behind the scenes, talking with the client, meeting with medical professionals, or talking with medical people, talking to your client about what happened, calling witnesses, and trying to prepare them for a hearing if that's necessary. So you do have to have a lot of compassion in order to do this kind of job right, because you have a lot of client contact. In the workers' compensation firms that are profitable or very profitable, they tend to have people who are paralegals or legal assistants who are doing the hand-holding and deal with the phone calls, because some of these workers' comp as well as SSDI cases, the clients tend to be stuck at home because they are having a lot of medical issues. And at the same time, especially if they're not getting any payments or any benefits right now, if their claim has been denied, then they're going to basically use your firm or your office as the place to vent all of their frustrations. So be prepared for a lot of phone calls, like, why aren't you doing anything for me? I don't have any money. I'm running out of money. I don't know how I'm going to pay my bills. So that's why it's important to also be keyed in on what social services are available around where your clients live, like where the free medical clinics or the sliding scale medical clinics, or where can the person get medication, or who are the doctors that are willing to give second opinions, which typically the law firm has to front the costs for. And especially for Social Security disability clients. So that's another administrative law forum where you don't actually go into a court, but you go to a hearing with an administrative law judge who decides whether the person is entitled to Social Security disability benefits. And by that means that the person is not able to work or has no earning capacity. And it's definitely easier when the person is at least 50 or more years old. Otherwise, if you get like a young 30-year-old or somebody who has a college degree, there are many factors that have to be met in order for the judge to find that the person is not able to work and is actually disabled and entitled to Social Security disability benefits. With those types of cases, that's even harder, I think, than workers' comp in a way, because of how slow the process is. From the time that the person is denied, they apply first, which you can now do online. If they get denied, then they request a hearing, or, well, it's been so long since I've done this, you appeal. Ultimately, you want to get a hearing, but it could take maybe even 2 years before you get a hearing before an administrative law judge. And then even after the hearing, it could still be many months before you finally get a decision on the case. So all through this, you're not getting paid by the hour, the client's not paying you anything. And ultimately, with Social Security disability cases, the attorney gets paid at the very end if they prevail. So thus, all of those like daytime TV commercials that you might see where attorneys are saying free consultation and we don't get paid unless you win. Well, typically those are the personal injury or workers' comp or SSDI attorneys. So that kind of gives the general public the impression that all attorneys are going to work for them for free, unfortunately. So along with the SSDI and workers' comp, you do have to be able to get along with and work with people from all socioeconomic backgrounds, people that might not be from the same privileged, educated background that you might be from. And you have to really be able to talk and listen to people, to be very patient, to be able to break down things so that they can understand what's going on and assure them that, yes, you are still handling their case, you're doing this, doing that, you're working for them, even though it seems like nothing is happening for your case. Practicing workers' comp as well as SSDI, sometimes I felt like I was a social worker because the people would be constantly calling and telling me about all their problems and having issues with getting food, getting the correct medical care, just being depressed because of their injury and inability to work or get out of the house. So I remember I would do a lot of extra things for these clients, like, for example, meeting them at night at a McDonald's just because it was easier to meet them there, or meet somebody at a Bojangles, again, because out of convenience for the person or for their family members. Sometimes I would visit my clients when they were in the hospital, or went to a couple of funerals and met their families. And I even once went to a client's home, which was in a not so good area of Durham, to give him his settlement check. So after having practiced for so long, I don't think I would really bend over backwards or potentially put myself in dangerous positions like that again. But another mistake I made was one time, back in the days when people actually had landline phones, I made a mistake of calling my client's mother from my home phone number. So she saw my number that way, and then after that proceeded to continue calling me at my home number at all sorts of weird hours and at night. So that was the lesson learned. But after I started my own solo practice back in 2006, I had a few SSDI and workers' comp cases that I either took from my former firm or, cases that somehow got referred to me through other clients or people I knew. But after a while, just like with the personal injury cases, I quickly realized this is not good. I'm spreading myself too thin, and without the big office staff to help me handle all of these phone calls and emails and, clients that keep wanting to meet and complain to me all day, it's not financially feasible for me as a solo practitioner to be handling these workers' comp plaintiffs' cases or SSDI appeals. So I also remember having a talk with a young guy who was in law school at the time, like a family friend's child, and I mentioned that I did Social Security disability appeals as part of my practice in addition to the other areas I was doing back then. And he just made this innocent comment like, oh, but don't those cases not pay well either? And in the back of my head, I was like this almost, quote, starving, not really starving, literally, but, I was like scraping by as a new solo practitioner. And I'm thinking, well, geez, I could make about $6,000 if I win this Social Security disability appeal. And boy, it would be great to me to earn $6,000 on a case. I don't know what you're talking about. I mean, well, anyway, it's all relative, right? What is considered a big jackpot or big money to someone, especially when you're a solo practitioner. So ultimately I decided that, okay, I'm just going to cut out these areas of law because the bigger firms, the ones that have a ton of money to do tons of advertising, daytime advertising and, direct marketing, things like that, Those are the firms that get all of the clients, and they have the staff to weed out the bad cases and deal with all of the work that needs to be done to build up those types of cases. So that's why I haven't handled those areas of law anymore. But if you guys have any questions about the general practice of law or any other areas, feel free to leave a comment. Hopefully this was a little bit informational and educational to you. And thanks for watching and subscribing.